Welcome to the Colorado Fertility Advocates webinar on the new Colorado Surrogacy Agreements Act, which went into effect on May 6, 2021. So it's now been in effect for almost 2 months, very exciting. And we generally think it's an extremely positive thing for Colorado, but we have all these professionals here gathered to talk about what it says, what it means, both to patients as well as professionals in the area. So we will get to hear from, and I'm just going to go around from my circular place. We'll have Dr. Allison Wilson, who will be speaking on the mental health piece of the new act. We have Amanda Kennard-Foxgruber, who is a gestational carrier herself and can talk about her experience and how a law can very much affect that from a surrogate's point of view. Judith Haight, who is, and I apologize, despite like 10 years of like working on your last name, Hakext.
Oh, you got it.
Who amazingly was one of the driving forces for passing this law. So she can even tell the ins and outs of how it got passed and all the thinking behind it, which is incredible to have as part of this. We have Jennifer White, who's with who runs an agency, who can talk about how all the agencies and those working with the agencies are affected by the new law. And Dr. Althea Shaughnessy with Conceptions, who is a reproductive endocrinologist in the area. And so the doctor's point of view of the new law as well. To start, we're going to have Judith talk about kind of what brought this about and how it came to be. So take it away, Judith.
Thanks, Ellen. So my name is Judith Hakext, and I am a licensed attorney in Colorado. I did not originally practice in this area of the law, which is assisted reproductive technology law. I came to this area of the law to practice in this area after struggling with infertility myself, my husband and I, for a long period of time. By my background, I am a licensed registered nurse. I went to nursing school first before attending law school. And my specialty areas were pediatric intensive care and some very high acuity pediatric intensive care units. I worked in a level 3, actually several level 3 and 4 neonatal intensive care units, one at Case Western Reserve University, and also in Denver at Presbyterian St. Luke's Hospital. And I also was a pediatric and adolescent oncology nurse at the Cleveland Clinic. I seem to be able to, care for children my whole life. I started babysitting at a young age because I always loved babies and children. And I was that kid who walked around the neighborhood and knocked on doors of people who had babies and asked if I could walk their babies in the strollers. And oddly enough, they let me at a very young age. And so I grew up loving children and always thinking that I would be a mom one day. And yet, I could care for everybody else's children, but I could not have a child of my own. It really was a rough journey. My husband and I started trying to have a family when I was just getting ready to start law school. We had, I was able to get pregnant several times, but miscarried each time. Then I had trouble getting pregnant. And it wasn't until many years later that when I moved to, it's just the strangest story. I was on a flight, I was living in Denver and practicing medical negligence law in Cleveland for a firm that I had worked for when I was in law school as a law clerk. And then I had practiced medical negligence law, both on the plaintiff's side and then for the defense side, and had done massive tort litigation. And I was on a flight back from Cleveland to Colorado. And oddly enough, in the seat in front of me in the pocket was a magazine that listed fertility clinics around the country. And my husband and I had really come to the end of our rope. It's incredibly stressful, as everybody knows, to struggle with infertility. And I just kind of tore that page out of the magazine and said to my husband, I'm just going to go get information, because I was one of those people who said, I'll never go through in vitro. And I've learned in my life to never say never. That was really the beginning of my journey through assisted reproduction. I was able to go through in vitro to have my children. And I was able to carry my first pregnancy and carried it beautifully. I just had a perfect pregnancy, but at delivery had severe complications that were completely unexpected and almost lost my life during and after delivery from hemorrhaging. And as much as I wanted to have a second child and carry a second child, it was advised after some failed mock cycles that we move on to surrogacy. And so I started to research going through surrogacy. I was already an attorney. I was still practicing part-time as a NICU nurse. And I started to look at the laws on surrogacy in Colorado, which there were no surrogacy laws, no statutes here. I couldn't find any case law, cases that had gone to court about surrogacy. So I started looking around the country to see if there were any states that were pro surrogacy, any states that were against surrogacy or found surrogacy to be illegal. And I kept being drawn back towards California because California had a great surrogacy statute for gestational surrogacy. And in fact, they even supported a little bit later genetic surrogacy agreements because they looked at the intentions of the parties that entered into the agreement. So when I looked for a surrogate, I looked for one eventually in California. My fertility clinic did a great job of screening our surrogate medically, actually walking me through the steps because I found my surrogate without an agency. We didn't, our reproductive endocrinologist suggested we could look either online, which at that time there were two websites where they had great surrogates come through at the clinic and had done a great job, had been great surrogates. And he gave me the names of two agencies. So I researched all, and I ended up finding a surrogate on my own in California. So the reproductive clinic did a great job of walking us through the steps that were needed to be completed to go through surrogacy. We had legal representation, and I was able to go out to California. My husband stayed behind because we had a 2-year-old, and so somebody had to be home with her. It wasn't easy for all three of us to travel together. And so I was able to go out to California about 4 times during the pregnancy for prenatal appointments. It's not the easiest when your surrogate doesn't live in the same state, but we accommodated, and we accommodated well. At the time that our son was born, the 3 of us flew out to California. My sister flew in from the East Coast, and it was quite a celebration. It was just truly magical and intimate in every possible way. In fact, it makes me cry just thinking of it, because we have this beautiful son, due to this selfless woman who did this for us. We were able to obtain a parentage order in California without any difficulty whatsoever. We added our son to our health insurance. We came home, and it was pretty remarkable. It was my reproductive endocrinologist who actually said to me, you really need to think about practicing in this area of the law because you walk the walk, you've struggled with infertility, you've gone through assisted reproduction to have a child, you're a nurse, you're comfortable talking to people, really think about this. And so he's the one that got me thinking about working in this area. And I started practicing in this area in 2010. I couldn't forget though, even though I was, had my 2 children and my family was complete, I could not forget that we didn't have a statute in our state. And while I represented, many clients who had assisted reproduction journeys within our state or who touched our state and whose contracts I drafted or contracts I reviewed, it bothered me that we have such great reproductive care in our state. It's probably the best in the nation. And yet we don't have a statute here. People come from all over the country and all over the world to Colorado for reproductive care, yet we didn't have a statute. So Ellen and I practice in this area. What did we use to support our argument to the Boulder District Court that the judicial magistrate should sign our parentage orders? A parentage order is an order signed by the court that tells the world that the intended parents, the people who intended to have a child, are the parents, the legal parents of that child, and it relinquishes the surrogate of legal responsibility and financial responsibility to a child that she never intended to have. So it's to support her, it's to support her spouse if she's married, or her partner, and it's to support the intended parents, but also it's to support every single baby born through surrogacy to know who its legal parents are. And so probably in about 2012, I first approached reproductive attorneys in Colorado to ask them, how do you feel about working on a surrogacy statute? I had, just prior to that time, my kids went to school with a former state representative who had just stepped down from that position. And he actually, his name is Joe Rice. He took me down to the Capitol and introduced me to legislators. He introduced me to the Speaker of the House. He introduced me to a lobbyist who was willing to take on lobbying for a statute in Colorado because she herself had struggled with infertility. And, you know, we know that so many people touch our lives, even not being in this profession, that struggle with infertility. It's 1 in 8 people. And she shared her story with me, as did some of the legislators down at the Capitol. So I came back from that visit and contacted other art attorneys in Colorado, and nobody was on board to have a surrogacy statute drafted. And the quote that I got several times was, if it's not broken, don't fix it. And so that left attorneys like Ellen and I trying to support our argument to the court when it came time to ask for a parentage court order to be signed by the court to give to the Vital Statistics Agency in Colorado to direct them to put the intended parents' names on a birth certificate. You know, we had to piece together parts of something called the Uniform Parentage Act to support why that legal argument to the court was correct. So we knew that we lived in a surrogate-friendly state, in part because the Boulder District Court would sign those court orders. But by history, no Denver judges would sign those court orders, nor would other judges throughout the state, because there was no statute. So Ellen and I and other attorneys did start to worry over time, particularly when politics change and there's a change in administration and there's a change in judicial officials. What if our magistrate left? Would the next magistrate sign the court orders? Because all they're looking at is the Uniform Parentage Act. There's no statute and there's no case law to support our arguments. So I didn't do anything for a number of years. And in 2018, Joe Rice introduced me to Representative Meg Froelich, who he really respected. And he thought that if I talked to her about it, if my colleagues and I had a change of support, I asked Meg if she would carry a surrogacy statute for us. So I met with her, with attorney Laura Kopel in 2018, and explained to her, she had no idea what assisted reproduction was. She had not struggled with infertility, and she really knew nothing about surrogacy except for what people read in the news. And it's usually something bad, or often something bad, a story that's gone wrong in the news. And so she was very intrigued by it. And she said she would be very interested in it and would, she said that she wouldn't carry it. She couldn't carry it in 2018 because the legislative session was over, but she would be very interested in speaking to us in 2019 about it. And so Laura and I approached her in 2019, and she asked us, again, she spent time with us, but she really didn't appreciate or understand. She has no medical background, no fertility difficulties. So she really didn't understand yet, which many people don't, what this is all about. Laura and I met with her a couple more times. We got input from our colleagues around the state, and there's probably, I'm not counting perfectly, but probably 6 or 7 of us, Ellen, do you think, who practice in this area? Is that a good estimate?
8 or 9, but
yeah, 8 or 9. Okay. But everybody gave input. Some people were more supportive than others. Laura and I drafted the statute based on the Uniform Parentage Act, because what our colleagues did tell us was they didn't want anything to change as far as making it more restrictive or even less restrictive, because it was working well under the Uniform Parentage Act. So we drafted it based on the Uniform Parentage Act, based on the input of our colleagues. And I also used the American Bar Association has an assisted reproductive technology committee, and I worked on a model act for assisted reproduction, which was drafted under the ABA's art committee. And so I had worked on that act. We wanted to make our language gender neutral when we drafted the Surrogacy Act. And we did do that, and we used a lot of the definitions from the Model Act on Assisted Reproduction. That Model Act was drafted in hope of attorneys around the country using it when they draft legislation. And so we used it to draft the statute. We finished drafting it we worked on it in November and December of 2019. We sent it to our colleagues. Our colleagues had input and gave us advice. They would like this, they didn't like that. And so in January of 2020, I'm sorry, the year that disappeared in COVID, in January, it was ready to go to the legislature. But Representative Froelich waited until, I believe it was early February, to introduce it at the Capitol. It was introduced, and then the next step, and we learned this process, as we were going through it, because it is quite a process. It's introduced by the representative. It moved with a vote to the House committee. I believe it was the House Health and Insurance Committee. And then the attorneys have to prepare witnesses to testify before the House committee hearing. And so we had about 11, I think about 10 or 11 witnesses. We had Dr. O'Shaughnessy testified as our reproductive endocrinologist. Judy Becerra testified as our mental health care counselor. Laura and Ellen testified as art attorneys. I testified with 2 other intended parents. We had 3 intended parents, and then we had 3 surrogates, and everybody's story was so compelling. On the day that we testified, which was Friday the 13th of 2020, we had, I believe, 11 legislators in the room, and they were in tears listening to the testimony. It was so compelling. I actually cried. I never intended to cry, but you tell your story.
I appreciate it too, and so I love it. Do you mind maybe wrap up the story?
I'll wrap it up. Yes, thank you.
So many people to get to. Thank you.
Okay, and so anyhow, it went through a unanimous vote, and then the Capitol shut down the next day because of COVID. We came back a year later, and most of the testimony was virtual in the House committee hearing, but it passed, not unanimously, I think because it was virtual. But it moved then to the House of Representatives. It passed through to the Senate. We had to prepare our witnesses again for the Senate committee hearing. It passed through that and 2 votes on the floor. And ultimately, Governor Paulus signed it on May 6th of this year, and it was effective immediately. And Ellen and I were there with Laura Copel and our families, and it was just a remarkable day. And that is the history and the process.
That was excellent.
Okay.
I'm going to share our screen to share about what it says, this amazing thing that we passed. So let's see if I can share a screen. Can you guys see that? Okay.
Yes.
So after all that amazing history, all the people who worked so hard to pass this, because we really didn't have the protections in Colorado, let's go over what the new law says. And remember, it's in effect now. It started May 6, 2020 upon the governor signing. Oh, and I was having problems moving it. Okay. So first, of course, the purpose, as Judith talked about, was to establish consistent standards and procedural safeguards to protect all parties in the surrogacy agreements, and to recognize the technological advances in assisted reproductive medicine and allow them to be used according to public policy of the state. So this is within the law. It says the purpose of the law. So generally speaking, so we know it went into effect May 6th, currently in effect, it applies to surrogacy. And that includes now both gestational and genetic surrogacy. Gestational being when the surrogate is not genetically related to the child, that the process happened by an embryo transfer. Genetic surrogacy being also known as traditional surrogacy, where the surrogate is also genetically related to the child, which could be by an embryo transfer or could be by an IUI to create that pregnancy. And it applies the law equally to both types of surrogacy. Important to remember that when we go over all these provisions and requirements, it does not apply to any other form of assisted reproductive technology. So none of these requirements apply to egg donation, sperm donation, embryo donation. It only applies to surrogacy. Okay, surrogate eligibility requirements. So this, for anyone thinking about being a surrogate or going through an agency, these will not be a surprise. These are just codifying best practices and basic standards that have already been in place. So the surrogate must be at least 21 years of age, previously having given birth to at least one child. She has to complete a medical evaluation with a licensed medical doctor, a mental health consultation by a licensed mental health professional, and have independent legal representation of their choice throughout the surrogacy arrangement. For the intended parents, similarly, they have to be 21 years of age, medical evaluation, independent legal representation. They don't have the mental health consultation requirement for the intended parents. One thing that's really important to note is that intended parents are not required to be married. They're not required to have a partner. You can be single, and you don't have to be genetically related to the child of the surrogacy. So meaning so many different forms of families can be supported by this. So single, LGBTQ, embryo donation, and a surrogate, all of those are supported by the law. So when does the law apply? So it can be tricky because generally if you are in Colorado, and by in Colorado, the surrogate being in Colorado, because if an intended parent is in Colorado and a surrogate's in another state, it might not be that you're relying on Colorado law, but you could, because the jurisdictional ties are one party being a resident of Colorado, or, so it's all ors, the birth will occur or is anticipated to occur in Colorado, or even just the assisted reproduction performed pursuant to the surrogacy agreement will occur in Colorado. So it could be that all parties are not in Colorado, but the embryo transfer, for example, takes place here, and you could still rely on this new Colorado law. Important parts of it. So one thing that was important in the new law was to be clear that anyone could terminate the surrogacy agreement so that a surrogate or intended parent could walk away without there being any penalty to do so. And of course, that is prior to her becoming pregnant. Other requirements, so pretty basic, but everyone must sign the agreement in front of a notary. The agreement must be signed before any medical procedure related to the surrogacy agreement, which really tends to be the transfer or starting medication for the transfer, before those take place. But of course, the evaluation and mental health consultation can take place before signing the legal agreement. IPs, the intended parents may pay for the surrogate's attorney. Intended parents may compensate the surrogate. That's really important because some states had permitted surrogacy but said not if she's compensated. So here the Colorado was very specific that yes, the surrogate may receive compensation. That is legal and supported. And then there's also very specific provisions to deal with complications of a divorce of parties during it or a death to see how that would be addressed. Parentage orders, so really good of the statute. We'd already been able to get pre-birth parentage orders here, but now it's very explicit that statute permits both pre and post-birth orders. And as long as your agreement is following the law, it shouldn't be in the discretion of a judge who might feel differently about your family. Here, they follow the law and they have to grant the pre-birth order pursuant to the law. One thing that's really important to remember for out-of-state attorneys, out-of-state organizations, is that if you got a pre-birth parentage order or other parentage order out of state, it is not considered valid in Colorado until it's been registered with the Colorado Court of Competent Jurisdiction. So also called domesticating the order. So you can't rely on out-of-state order until it's been domesticated, which often means it might just be easier to get a Colorado order directly. So that was the quick overview. And now I'm excited to go to the other professionals and their thoughts and opinions on the new law.
Great.
Next
think
up.
I'm next.
Thank you.
And what a comprehensive law. I feel fortunate to live here in Colorado, where we're just really about anybody who wants to have a baby. It's their right to do so. So I'm thrilled to talk about the mental health piece of it. So as Ellen mentioned, the law now requires that the surrogate must meet with a licensed mental health professional before she proceeds with the process. And I think that is standard, but I'm glad it's now part of the law. It is immensely helpful for all the parties involved. And I'm going to start with the intended parents. As many of you know, it's hard enough to go through fertility and treatments, and then you have to relinquish control and trust that this woman who is doing this service is going to do what she says and take care of your baby. And that's really hard to do and very stressful, very expensive. And so having her now required to meet with a mental health professional who's licensed just gives the intended parents, I hope, another layer of reassurance that, okay, another set of eyes are on this. The mental health professional ideally is trained in this area. And the purpose is really not only to make sure that the surrogate she meets the mental health criteria to serve as a surrogate, but the mental health professional allows her a space to talk about this plan. And what does she think about it, and if there's any red flags. And I would hope that comforts intended parents, knowing that yes, a licensed professional is advocating for them as well. This also helps the surrogate herself. It's a big decision, and meeting with a mental health professional, she has a chance to really talk about it with a neutral party, which I think is very important. And she can, discuss her fears, why is she doing this, and just get some help and education along the way. And the mental health consultation can help to see, is this the right decision for her to serve as a surrogate? Is it the right decision for the intended parents? And is it the right decision for the child to be? So it's really, really helpful. As Ellen mentioned, it's not required for the intended parents to meet with a mental health professional, but I'm going to make that plug that it's highly recommended. Most reputable clinics and agencies will make it a recommendation anyway. And I think that's another opportunity for the intended parents to have a chance to get educated, to grieve, to express questions, fears. It's really, really helpful for that dimension of the process. And then lastly, I think by having the surrogate meet with the mental health professional who's licensed in Colorado helps the agencies and attorneys in this area too, because there's a lot of gray areas that might be not so law specific, but it's grayer than that. And a mental health professional can really help, agencies and attorneys deal with certain aspects, but also knowing that the surrogate was met with the mental health professional before we even got this going. So that's my part. I'm going to hand it back over to you, Ellen.
That was great. Thank you.
Mm-hmm.
Dr. Shaughnessy, do you want to talk about the medical piece? And you're muted. Classic. Classic.
Yeah. All right. Hi, I'm Dr. O'Shaughnessy. I'm a reproductive endocrinologist with Conception's Reproductive Associates. And this is a welcome statute. I can't emphasize that more for us anyway. Obviously, we follow all the things that are in the statute, and most physicians in Colorado do as well, but some don't. And in the old days, things were a little wishy-washy. They didn't follow the criteria strictly, and I think it actually can cause tremendous problems with both the surrogate and the intended parents. So this is wonderful. So let's kind of go through what these criteria are and why they're important. So first criteria, the surrogate has to be age 21. Well, why does that matter? Well, I think that a surrogate, gestational surrogate has to be mature enough to make that decision, and that surrogate has to have had a baby that was born. Obviously, that makes sense. Number one, psychologically, that makes sense. You don't want your first pregnancy to be a surrogacy pregnancy. And number two, you want to make sure that you're healthy enough to carry a pregnancy. And so that's kind of part of their evaluation, is looking at their OB records. I would say majority of gestational carriers have had more than one pregnancy. And many of them have had have done gestational surrogacy. This would be their second time or third time. So all those things are very, very, very important. Now, in terms of the medical evaluation, all that came from obviously what's recommended by the American Society for Reproductive Medicine. They actually came out with recommendations as to what they think surrogacy should look like, and that's safe. So the medical evaluation for the gestational carrier is basically, is she healthy enough to carry a pregnancy? So reviewing her OB records, making sure there's no complications during her pregnancy that may affect a subsequent pregnancy, making sure her medical history is good and she's healthy. And then, of course, blood tests that you would do on anybody who's trying to get pregnant. And we do infectious disease testing for obvious reasons. So the gestational carrier obviously goes through quite an extensive medical evaluation, and of course then undergoes the mental health evaluation as well. In terms of the intended parent, we do have to do infectious disease testing. They're kind of considered donors because we're putting an embryo from the intended parent, usually, not always, into this gestational carrier. So if the gametes, like the egg or the sperm, comes from the intended parent, then we have to test them. And they're called FDA tests, and they're special tests that you have to do, infectious disease testing. That's mainly the tests that we do on the intended parent. So I think that, obviously one of the things that's stipulated is that when a gestational carrier is trying to get pregnant, they have to do it with assisted reproductive technology. They can't just have intercourse, basically. So it protects everyone. It's very scientific, very controlled. And so again, this is wonderful. I think that people will find that gestational surrogacy, because of this, will become more mainstream and less of a stigma, to be honest with you. So I think that's most of what I wanted to talk about. Yeah.
That was great. And I do just want to say that, in theory, traditional surrogacy, some people believe that you could have sexual intercourse to create that surrogacy, but under the new law, that is not the case. That you have to have a doctor involved. It must be through an IUI or other procedure. So
that is correct.
You need Dr. O and her experts like
me.
Thank you. That was great.
Yeah,
and now for the agency point of view, Jennifer White.
Hi, I'm Jennifer White. I'm the director of Bright Futures Families, which many people locally know as Colorado Surrogacy, which makes it fun that the law is, the Colorado Surrogacy law. It feels really special and awesome to me, quite honestly. It wasn't intentional for us, but it feels good. I want to echo what Dr. O said, that the great thing about this is it didn't affect us, because we were already doing what we needed to be doing. All of these things were things that we did. We always sent everybody out for mental health evaluations. We were always using a licensed medical provider who was providing all of the medical evaluations throughout. All of our surrogates are of the appropriate age and following ASRM guidelines and going through all of this screening. So that's good. But as she said, sometimes there are agencies out there that are not doing those things. And this brings everybody up. And the only way that we can bring surrogacy into a place where it is mainstream and everybody's accepting it is if that we bring everybody up with us, and we all want to be strong together, and we want to make sure that everybody is following the rules, because we want to protect intended parents and we want to protect gestational carriers all the way through this process, because both are really important. I mean, I joke all the time that an agency's job is we're a party planner, and the party at the end is holding a baby, and yay, that's what it is. But I mean, that's really what this is, just guidelines on how to have a really great party and get there and have everybody be happy at the end. So I want to keep it short and sweet, because I mean, everybody has said these things, and quite honestly, like I said, it's best practices, and it's what pretty much everybody and every agency should have been doing up until now. So agencies shouldn't have been affected by this. This is a good thing, right? So I'm gonna hand it back, because I don't have anything additional to add, and I think that's good.
But affected in a positive way. Now
It did affect it affected the entire industry in a positive way, and that is good for all of us.
Now the law says how to throw your party. Excellent.
Exactly.
Thank you, Jen. Amanda, would you like to share your thoughts from a surrogate's point of view?
Sure. First of all, I will second what Allison says. I know mental health is not required for the intended parents, but being a gestational carrier, this process is a lot. You have to have a lot of trust, and you have to let go of a lot of control as intended parents. So it's definitely something that's great to talk through beforehand. Just knowing from the gestational carrier side and having that screening, it brought up questions and things to think about that I wouldn't have thought of otherwise. So the law is great because it gives clear expectations. You have your own independent attorneys. I think even the best part is that the attorney represents you throughout the process. So it's not this, oh, we do the gestational carrier agreement, we have no contact with you throughout. Oh, we talk to you, for pre-birth order, and then we're done. I can't call you or consult you or anything. So that's super important, because those gestational carrier agreements, I get Judith and Ellen love them and understand them.
They're so good. They're so clear.
I won't say that's true for everyone. So having that access to be able to call and ask questions, or, if there is a discrepancy between what I think the contract says and what my intended parents say, being able to call and ask about that is something that I think is super important from a gestational carrier point of view, because I'm not put in the middle. They're not put in the middle. We can ask, what was the intention of this document? And I think there again, another great part is, the parents are going to be named the parents. There's not this, oh, it's just because of precedent. Oh yeah, we usually file it in this court. Yeah, it goes through. No, there's a law that says they will be named the parents. So that's super reassuring as a gestational carrier, because I didn't want to bring another child home. This was their baby. I wanted to give it back to them. They needed to be named the parents and take full responsibility. And so having a law that states that that is what's going to happen is amazing.
No, that's great. Thank you. So if anyone wants
Ellen,
to,
yeah, I just wanted to add to what Amanda said, because my husband and I had mental health counseling at our clinic, and neither of us felt that it was like an investigation into our, whether or not we should be allowed to be parents through surrogacy. Our mental health counselor had great insights and advice, actually, about how to negotiate this very intimate relationship, but where you're totally out of control. You have no control, and somebody else is carrying your child that you have to trust to carry your child. And how do you navigate boundaries? How do you navigate the relationship? And it was really, really helpful. The other point that I wanted to make was that when we drafted the statute, we actually looked at the ASRM recommendations for surrogacy and used that within the drafting of the agreement. And the last thing that I wanted to say is that our clients, and I bet Ellen will speak to this as well, that they are so thrilled that there's a statute, and they have this sense of relief And many of our clients will come back for a second surrogacy. And I have 2 clients right now who are on their 3rd surrogacy to have a 3rd child. And they're so relieved to hear that there's a statute in place, even if they had no hiccups in their prior journeys. They just are so pleased about it.
Yeah.
Well, and I would always tell the story that there was another state that was very similar to Colorado where things had just been going smoothly, but there was no law. And then suddenly this judge had very strong opinions and put this poor family through an absolute nightmare of denying parental rights, not giving parental rights to surrogate, saying the child was a legal orphan, and just like putting them through absolute hell.
It was horrible.
Well, I also like to think when I meet with couples or individuals, intended parents, surrogate, we all as a team, we hope for the best, but we plan for the worst. And this law helps to give us that reassurance that, okay, it's not just an opinion, it's not a standard, it's the law. And I also really like this law because it allows whoever you love, or if you're in a relationship, if you're single, you have a shot at doing this. And I really appreciate that part about it.
The other part of it, the genetic surrogacy part of it, we've had clients contact us who on their own got pregnant at home using an apparatus like a turkey baster to do at-home inseminations. And, they have various reasons for doing it. Cost is one, and it can often be a huge one for why they're doing it that way. And, we attend a lot of assisted reproductive law conferences, and we are educated to make right things that aren't right from the beginning, that it's our duty as attorneys and our obligation as attorneys to protect the interests of the child who's coming to try to make this right. So I have had clients who did it at home on their own and had no contract to begin with. Fortunately, the Boulder District Court has signed parentage orders in those cases. But again, as attorneys, we worry about that. The other part of it, I think, is we have an obligation when we have clients approach us who want to do a genetic surrogacy to advise them to go through the right steps to do it. So as a nurse, even while I'm not practicing law right now, I would say, don't move forward until you have medical screening that it's like getting pregnant on your own. You want to get the approval of your OB, make sure you're in great health, you don't have any communicable diseases, including sexually transmitted diseases, that you're on prenatal vitamins, that you've had this, but also the sperm donor or contributor needs to be screened as well. And, oh, by the way, you really do need to speak to a mental health care provider who's experienced and educated in this area, so that you know what the boundaries are and what to anticipate going into this. And so I would refer my clients on to other people, but sometimes maybe somebody else isn't comfortable seeing a client because there is no law and they're not comfortable with genetic surrogacy. So I think this law helps people to understand what they need to do. And it gives people just a deeper sense of comfort. And okay, they do want to do genetic surrogacy, even though I don't usually handle patients or many patients who do that, I can see them more comfortably now because there is this law.
Great point. From our few live participants, if you have any questions, we'd be happy to take them at this time. Alternatively, if you have questions later, or if you're watching this later, all of us are happy to be a resource. You can either contact the organization Colorado Fertility Advocates through the info account, or I think all of us are listed as well if you want to contact us directly for any questions on mental health or medical or the agency or the experience of doing this. And of course, the attorneys. Oh, we do have a question. Okay. I'm gonna give this one to Dr.
Yeah. Okay.
Where might someone find a list of mental health providers?
That's a great question. I often tell people to go to the American Society for Reproductive Medicine's website, or asrm.org. And there's a section for patients, and you click on it, and then there's find a healthcare professional. and you click on that, enter Colorado, and you should see a list of providers that are a part of ASRM, which gives me some comfort that there's probably been some training. They know what this is. So that would be where I would look. Second is you might look at Resolve, their organization. They're a nationwide advocacy group, and they often have lists of mental health professionals that also specialize in this area.
Hey, Allison, can I plug for you to like push on SciPact too, and that might give people more resources as well?
Absolutely. So for a licensed psychologist, like myself in Colorado, there has been a recent laws in different states where it allows me to practice through telehealth in a different state. And the SciPact website has all the states that participate in this pact, if you will. And so if you're located, let's say in Colorado, but your surrogate is somewhere else, you might want to look at the SciPact list and see, mental health professionals that might be able to do the screening for your surrogate there or provide the help. But that would be for licensed psychologists. So yeah, thanks, Jen. Great question.
That's great information. Well, I'll give it another few seconds before we completely wrap up and end the call. But thank you guys for sharing your expertise, sharing your time. For those watching, these are definitely the pros in the area who can be of assistance with any question you might have. Okay. Well, we will stop the recording, but thank you for watching, and congratulations to Colorado and all the families being formed under these new protections.
Thanks, everybody.